Hi friends, welcome to Posh Pro HR, your go-to channel for everything HR. In today's video, we are diving into a crucial piece of labor law that every HR professionals and business owners should be aware of the Payment of Bonus Act 1965. And now, it is also including Central Act number 21 of 1965. And now I will explain about the amendments. By Act numbers 62 of 1968, 8 of 1969, 51 of 1970, 68 of 1972, 39 of 1973, 55 of 1973, 42 of 1974, 56 of 1974, 23 of 1976, 43 of 1977, 38 of 1978, 48 of 1978, 5 of 1980, of 66 of 1980, 61 of 1981, 30 of 1985, 67 of 1985, 53 of 1987, 19 of 1988, 39 of 1989, 34 of 1995, and 45 of 2007. An act to provide for the payment of bonus to persons employed in certain establishments on the basis of profits or on the basis of production or productivity and for matters connected therewith, be it enacted by Parliament in the 16th year of the Republic of India as follows. 1. Short title, extent and application. This act may be called the Payment of Bonus Act 1965. It extends to the whole of India. Save as otherwise provided in this act, it shall apply to every factory and every other establishment in which 20 or more persons are employed on any day during an accounting year, provided that the appropriate government may, after giving not less than 2 months notice of its intention so to do by notification in the official gazette, apply the provisions of this act with effect from such accounting year as may be specified in the notification to any establishment or class of establishments, including an establishment being a factory within the meaning of subclause 2 of clause M of section 2 of the Factories Act 1948, 63 of 1948, employing such, published in the Gazette of India, Extraordinary Part 2 as 1 dated 25/9/1995 at 411, substituted by Act number 23 of 1976, Section 2, and shall be deemed to have come into force with effect from 25/9/1995. The words expect the state of Jammu and Kashmir, omitted by Act number 51 of 1970, Schedule and Section 1A. Provisions added by Act number 23 of 1976, Section 3A, and shall be deemed to have come into force with effect of 25/9/1975. Number of persons less than 20 as may be specified in the notification, so however that the number of persons so specified shall in no case be less than 10. Save as otherwise provided in this Act, the provisions of this Act shall in relations to a factory or other establishment to which this Act applies have effect in respect of the accounting year commencing on any day in the year 1964 and in respect of every subsequent accounting year. provided that in relation to the state of Jammu and Kashmir, the reference to the accounting year commencing on any day in the year 1964 and every subsequent accounting year shall be constructed as reference to the accounting year commencing on any day in the year 1968 and every subsequent accounting year. Providing further that when the provisions of the Act have been made applicable to any establishment or class of establishments by the issue of a notification under the provisions to subsection 3, the reference to the accounting year commencing on any day in the year 1964 and every subsequent accounting year, or as the case may be, the reference to the accounting year commencing on any day in the year 1968 and every subsequent accounting year shall in relation to such establishment or class of establishments be constructed as a reference to the accounting year specified in such notifications and every subsequent accounting year. An establishment to which this Act applies shall continue to be governed by this Act, notwithstanding that the number of persons employed therein falls below 20, or less the case may be the number of specified in the notification issued under the provisions to subsection 3. And now definitions. In this Act, unless the contest otherwise requires. Number 1, accounting year means in relation to a corporation the year ending on the day on which the books and accounts of the corporation are to be closed and balanced. Point number 2, in relation to a company the period in respect of which any profit and loss account of the company laid before it in annual general meeting is made up, whether that period is a year or not. Point number 3, in any other case, the year commencing on the first day of April, or if the accounts of an establishment maintained by the employer thereof are closed and balanced on any day other than the 31st day of March, then at the option of the employer the year ending on the day on which its accounts are so closed and balanced. Provided that an option once exercised by the employer under paragraph B of this subclause shall not again be exercised except with the previous permission in writing of the prescribed authority and upon such conditions as that authority may think fit. Agriculture income shall have the same meaning as in the Income Tax Act. Agriculture income tax law means any law for the time being in force relating to the levy of tax on agricultural income. Allocable surplus means in relation to an employer being a company other than a banking company which has not made the arrangements prescribed under the Income Tax Act for the declaration and payment within India of the dividends payable out of its profits, in accordance with the provisions of Section 194 of that Act, 67% of the available surplus in an accounting year. In any other case, 60% of such available surplus. Appropriate government means in relation to P, an establishment in respect of which the appropriate government under the Industrial Disputes Act 1947 and 14 of 1947 is the central government. The central government in relation to any other establishment, the government of the state in which that other establishment is situate. The bracket and words other than a banking company omitted by Act number 23 of 1976, Section 4A 1 and shall be deemed to have come into force with effect from 25/9/1995 and again inserted by Act number 66 of 1980. Section 2A and shall be deemed to have come into force with effect from 21 August 1980. The words brackets are figures and includes any amount treated as such under subsection 2 of Section 34. Prompted by Act number 23 of 1976, Section 4A, and shall be deemed to have come into force with effect from 25/9/1975. Available surplus means the available surplus completed under Section 5. Award means an interim or a financial and final determination of any industrial dispute or any question relating thereto by any labor court, industrial tribunal, or national tribunal constituted under the Industrial Disputes Act 1947, 14 of 1947, or by any other authority constituted under any corresponding law relating to investigation and settlement of industrial disputes in force in a state, and includes an arbitration award made under Section 10A of that Act or under that law. Banking company means a banking company as defined in Section 5 of the Banking Companies Act 1949, 10 of 1949, and includes the State Bank of India, any subsidiary bank as defined in the State Bank of India Subsidiary Banks Act 1959, 38 of 1959, any corresponding new bank specified in the first schedule to the Banking Companies Acquisition and Transfer of Undertakings Act 1970. 5 of 1970, any corresponding new bank constituted under Section 3 of the Banking Companies Acquisition and Transfer of Undertaking Act 1980. 40 of 1980, any cooperative bank as defined in Clause B of Section 2 of the Reserve Bank of India Act 1934. 2 of 1934, and any other banking institution which may be notified in this behalf of by the central government. Company. Company means any company as defined in Section 3 of the Companies Act 1956. 1 of 1956, and includes a foreign company within the meaning of Section 591 of that Act. Cooperative society. Cooperative society means a society registered or deemed to be registered under the Cooperative Societies Act 1912, 2 of 1912, or any other law for the time being in force in any state relating to cooperative societies. Corporation. Corporation means anybody corporate established by or under any central provisional or state act but does not include a company or a cooperative society. Direct tax. Direct tax means any tax chargeable under the Income Tax Act. The Super Profits Tax Act 1963, 14 of 1963, the Companies Profits Surtax Act 1964, 7 of 1964, the Agricultural Income Tax Law, and any other tax which, having regard to its nature or incidence, may be declared by the central government by notification in the official gazette to be a direct tax for the purpose of this act. Employee. Employee means any persons other than an apprentice employed on a salary or wage not exceeding 10,000 per annum in any industry to do any skilled or unskilled manual, supervisory, managerial, administrative, technical, or clerical work for hire or reward, whether the terms of employment be express or implied. Employer. Employer includes, in relation to an establishment which is a factory, the owner or occupier of the factory, including the agent of such owner or occupier, the legal representative of a deceased owner or occupier, and where a person has been named as a manager of the factory under Clause F of subsection 1 of Section 7 of the Factories Act 1948, 63 of 1948, the person so named, and in relation to any other establishment, the person who or the authority which has the ultimate control over the affairs of the establishments, and where the said affairs are entrusted to a manager, managing director, or managing agent such manager, managing director or managing agent. Establishment in private sector. Establishment in private sector means any establishment other than an establishment in public sector. Establishment in public sector. Establishment in public sector means an establishment owned, controlled or managed by a government company as defined in section 17 of the Companies Act 1956, 1 of 1956. A corporation in which not less than 40% of its capital is held, whether singly or taken together by the government or the Reserve Bank of India. Substituted for the words there 3000 rupees and 500 rupees by Act number 45 of 2007 and shall be deemed to have come into force with effect from 1st April 2006. A corporation owned by the government or the Reserve Bank of India. Factory. Factory shall have the same meaning as in clause of section 2 of the Factories Act 1948. 63 of 1948. Gross profits. Gross profits means the gross profits calculated under section 4. Income Tax Act. Income Tax Act means the Income Tax Act 1961, 43 of 1961. Prescribed. Prescribed means prescribed by rules made under this Act. Salary or wage. Salary or wage means all remuneration other than remuneration in respect of overtime work capable of being expressed in terms of money, which would, if the terms of employment expressed or implied, were fulfilled be payable to an employee in respect of his employment or of work done in such employment, and includes dearness allowances, that is to say, all cash and payments by whatever named called paid to an employee on account of a rise in the cost of living, but does not include any other allowances which is the employee is for the time being entitled to. The value of any house accommodation or of supply of light, water, medical attendance or other amenity or of any service or of any consumptional supply of food grains or other articles, any traveling concession, any bonus including incentive production and attendance bonus, any contribution paid or payable by the employer to any pension fund or provident fund or for the benefit of the employee under any law for the time being in force, any detachment, compensation or any gratuity or other retirement benefit payable to the employee or any ex gratia payment made to him, any commission payable to the employee, explanation where an employee is given in lieu of the whole or part of the salary or wage payable to him, free food allowances or free food by his employer, such food allowances or the value of such food shall for the purpose of this clause be deemed to form part of the salary or wage of such employee. 22. Words and expressions used but not defined in this Act and defined in the Industrial Disputes Act 1947, 14 of 1947 shall have the meanings respectively assigned to them in that Act. Establishments to include departments, undertaking and branches, where an establishment consists of different parts and departments are undertaking or has branches whether situated in the same place or in different places, shall be treated as parts of the same establishment for the purpose of computation of bonus under this Act, provided that where for any accounting year a separate balance sheet and profit and loss account are prepared and maintained in respect of any such department or undertaking or branch, then such department or undertaking or branch shall be treated as a separate establishment for the purpose of computation of bonus under this Act for that year, unless such department or undertaking or branch was immediately before the commencement of that accounting year, treated as part of the establishment for the purpose of computation of bonus. Computation of gross profits. The gross profits derived by an employer from an establishment in respect of any accounting year shall, in the case of a banking company, be calculated in the manner specified in the first schedule. In any other case, be calculated in the manner specified in the second schedule. Computation of available surplus. The available surplus in respect of any accounting year shall be the gross profits for that year after deducting therefrom the sums referred to in section 6, provided that the available surplus in respect of the accounting year commencing on any day in the year 1968 and in respect of every subsequent accounting year shall be the aggregate of the gross profits for that accounting year after deducting therefrom the sums referred in section 6 and an amount equal to the difference between the direct tax calculated in accordance with the provisions of section 7 in respect of an amount equal to the gross profits of the employer for the immediately preceding accounting year and the direct tax calculated in accordance with the provisions of section 7 in respect of an amount equal to the gross profits of the employer for such section 4 quants are substituted by Act number 66 of 1980, section 4, and shall be deemed to have come into force with effect from 21 deemed to have come into force with effect from 21 August 1980. Provision added by Act number 8 of 1969, section 2, with effect from 10th January 1969. Proceedings accounting year after deducting therefrom the amount of bonus which the employer has paid or is liable to pay to his employees in accordance with the provisions of this Act for that year. Sums deductible from gross profits. The following sums shall be deducted from the gross profits as prior charges, namely any amount by way of depreciation admissible in accordance with the provisions of subsection 1 of section 32 of the Income Tax Act or in accordance with the provisions of the Agricultural Income Tax Law, as the case may be, provided that where an employer has been paying bonus to his employees under a settlement or an award or agreement made before the 29th May 1965 and subsisting on that date after deducting from the gross profits national normal depreciation, then the amount of depreciation to be deducted under this clause shall, at the option of such employer, such option to be exercised once and within 1 year from the date. Continue to be such national normal depreciation any amount by way of development rebate or investment allowances or development allowances which the employer is entitled to deduct from his income under the Income Tax Act or in accordance with the provisions of the Agricultural Income Tax Law, as the case may be, provided that where an employer has been paying bonus to his employees under a settlement or an award or agreement made before the 29th May 1965 and subsisting on the date after deducting from the gross profits national normal depreciation, then the amount of depreciation to be deducted under this clause shall, at the option of such employer, such option to be exercised once and within 1 year from the date, continue to be such national normal depreciation any amount by way of development rebate or investment allowances or development allowances which the employer is entitled to deduct from his income tax under Act, subject to the provisions of section 7, any direct tax which the employer is liable to pay for the accounting year in respect of his income, profits and gain during that year. Thus, further sums as are specified in respect of the employer in the third schedule. Calculation of direct tax payable by the employer. Any direct tax payable by the employer for any accounting year shall subject to the following provisions be calculated at the rates applicable to the income tax of the employer for that year, namely in calculating such tax, no account shall be taken of any loss incurred by the employer in respect of any provisions accounting year and carried forward under any law for the time being in force relating to direct taxes. Substituted for the words development rebate or development allowances by Act number 66 of 1980, Section 4 by A, and shall be deemed to have come into force with effect from 21st August 1980. Substituted for the words second schedule by Act number 66 of 1980, Section 4 by Section 4B, and shall be deemed to have come into force with effect from 21st August 1980. Substituted for the words brackets, letter and figure for the purpose of clause C of section 6 any direct tax payable by the employer by Act number 8 of 1969, section 3 with effect from 10th January 1969. Any areas of depreciation which the employer is entitled to add to the amount of the allowance for depreciation for any following accounting year or years under subsection 2 of Section 32 of the Income Tax Act. Any exemption conferred on the employer under Section 84 of the Income Tax Act or of any deduction to which he is entitled under subsection 1 of Section 101 of that Act, as in force immediately before the commencement of the Finance Act 1965, 10 of 1965. Where the employer is a religious or a charitable institution to which the provisions of Section 32 do not apply and the whole or any part of its income is exempt from tax under the Income Tax Act, then with respect to the income so exempted, such institution shall be treated as if it were a company in such the public area sustainability interested within the meaning of that Act. Where the employer is an individual or a Hindu undivided family, the tax payable by such employer under the Income Tax Act shall be calculated on the basis that the income divided by him from the establishment is his only income. Where the income of any employer includes any profits and gains derived from the export of any goods or merchandise out of India, and any rebate on such income is allowed under any law for the time being in force relating to direct taxes, then no account shall be taken of such rebate. No account shall be taken of any rebate other than development rebate or investment allowances or development allowances or credit or relief or deduction not herein before mentioned in this section. In the payment of any direct tax allowed under any law for the time being in force relating to direct taxes or under the relevant Annual Finance Act for the development of any industry. Eligibility for bonus. Every employee shall be entitled to be paid by his employer in an accounting yearly bonus in accordance with the provisions of this Act, provided he has worked in the establishment for not less than 30 working days in that year. Disqualification for bonus. Notwithstanding anything contained in this Act, an employee shall be disqualified from receiving bonus under this Act if he is dismissed from service for any integrity issues. Substituted for the brackets and words other than development rebate or development allowances by Act number 66 of 1980, Section 5, and shall be deemed to have come into force with effect from 21st August 1980. Fraud or gratuitous or violent behavior while on the premises of the establishment, or theft, misappropriation or sabotage of any property of the establishment. Payment of minimum bonus. Subject to the other provisions of this Act, every employer shall be bound to pay to every employee in respect of the accounting year commencing on any day in that year 1979, and in respect of every subsequent accounting year, a minimum bonus shall be paid 8.33% of the salary or wage earned by the employee during the accounting year, or 100 rupees, whichever is higher, whether or not the employer has any allocable surplus in the accounting year. provided that where an employee has not completed 15 years of age at the beginning of the accounting year, the provisions of this Act section shall have effect in relation to such employee as if for the words 100 rupees, the words 60 rupees were substituted. Payment of minimum bonus, where in respect of any accounting year referred to in section 10, the allocable surplus exceeds the amount of minimum bonus payable to the employees under that section, the employer shall, in lieu of such minimum bonus, be bound to pay the every employee in respect of that accounting year bonus, which shall be an amount in proportion to the salary or wage earned by the employee during the accounting year, subject to a maximum of 20% of such salary or wage. In computing the allocable surplus under this section, the amount set on or the amount set off under the provisions of section 15 shall be taken into account in accordance with the provisions of that section. Calculation of bonus with respect to certain employees, where the salary or wage of an employee exceeds 3,500 rupees per mention, the bonus payable to such employees under section 10 or as the case may be under section 11 shall be calculated as if his salary or wage were 3,500 rupees per mention. Section 10 and 11 substituted by Act number 66 of 1980, Section 6 and shall be deemed to have come into force with effect from 21st August 1980. Section 12 inserted by Act number 67 of 1985, Section 3 and shall be deemed to have come into force with effect from 7th November 1985. Substituted for the words 2,500 rupees by Act number 45 of 2007 and shall be deemed to have come into force with effect from 1st April 2006. Substituted for the words 2,500 rupees by Act number 45 of 2007 and shall be deemed to have come into force with effect from 1st April 2006. Proportionate reduction in bonus in certain cases, where an employee has not worked for all the working days in an accounting year, the minimum bonus of 100 rupees or as the case may be of 60 rupees if such bonus is higher than 8.3% of his salary or wage for the days he has worked in that accounting year shall be appropriately reduced. Computation of number of working days for the purpose of Section 13, an employee shall be deemed to have worked in an establishment in any accounting year, also on the days on which he has been laid off, under an agreement or as permitted by standing orders under the Industrial Employment Standing Orders, Act 1946, 20 of 1946, or under the Industrial Disputes Act 1947, 14 of 1947, or under any other law applicable to the establishment. He has been on leave with salary or wage. He has been absent due to Section 6 and shall be deemed to have come into force with effect from 21st August 1980. Section 12 inserted by Act number 67 of 1985, Section 3 and shall be deemed to have come into force with effect from 7th November 1985. Substituted for the words 2,500 rupees by Act number 45 of 2007 and shall be deemed to have come into force with effect from 1st April 2006. Substituted for the words 2,500 rupees by Act number 45 of 2007 and shall be deemed to have come into force with effect from 1st April 2006. Proportionate reduction in bonus in certain cases, where an employee has not worked for all the working days in an accounting year, the minimum bonus of 100 rupees or as the case may be of 60 rupees if such bonus is higher than 8.3% of his salary or wage for the days he has worked in that accounting year shall be appropriately reduced. Computation of number of working days for the purpose of Section 13, an employee shall be deemed to have worked in an establishment in any accounting year, also on the days on which he has been laid off, under an agreement or as permitted by standing orders under the Industrial Employment Standing Orders Act 1946, 20 of 1946, or under the Industrial Disputes Act 1947, 14 of 1947, or under any other law applicable to the establishment. He has been on leave with salary or wage. He has been absent due to temporary disablement caused by incident and accident arising out of and in the course of his employment, and the employee has been on maternity leave with salary or wage during the accounting year. Set on and set off of allocable surplus. 1. Where for any accounting year the allocable surplus exceeds the amount of maximum bonus payable to the employees in the establishment under Section 11, then the excess shall, subject to a limit of 20% of the total salary or wage of the employees employed in the establishment in that accounting year, be carried forward for being set on in the succeeding accounting year, and so on up to and inclusive of the fourth accounting year, to be utilized for the purpose of payment of bonus in the manner illustrated in the fourth schedule. Where for any accounting year there is no available surplus, or the allocable surplus in respect of the year falls short of the amount of minimum bonus payable to the employees in the establishment under Section 10, and there is no amount or sufficient amount carried forward and set on under subsection 1, which could be utilized for the purpose of payment of the minimum bonus, then such minimum amount or the deficiency, as the case may be, shall be carried forward for being set off in the succeeding accounting year, and so on up to and inclusive of the fourth accounting year in the manner illustrated in the fourth schedule. Section 13, substituted by Act number 66 of 1980, Section 8, and deemed to have come into force with effect from 21st August 1980. Section 15, substituted by Act number 66, Act number 66 of 1980, Section 9, and shall be deemed to have come into force with effect from 21st August 1980. The principle of set on and set off as illustrated in fourth schedule shall apply to all other cases not covered by subsection 1 or subsection 2 for the purpose of payment of bonus under this Act. Where in any accounting year any amount has been carried forward and set on or set off under this section, then in calculating bonus for the succeeding accounting year, the amount of set on or set off carried forward from the earliest accounting year shall first be taken into account. Special provisions with respect to certain establishments. Where an establishment is newly set up, whether before or after the commencement of this Act, the employees of such establishment shall be entitled to be paid bonus under this Act in accordance with the provisions of subsections 1A and 1B and also 1C. 1A in the first 5 accounting years following the accounting year in which the employer sells the goods produced or manufactured by him or rendered services. As the case may be formed, such establishment bonus shall be payable only in respect of the accounting year in which the employer derives profit, and such establishment and such bonus shall be calculated in accordance with the provisions of this Act in relation to that year, but without applying the provisions of Section 15 and 1B for the 6th and 7th accounting year following the accounting year in which the employer sells the goods produced, or such establishment. The provisions of Section 15 shall apply subject to the following modifications, namely for the 6th accounting year. Set on or set off as the case may be shall be made in the manner illustrated in the 4th schedule, taking into account the excess or deficiency, if any, as the case may be, of the allocable surplus set on or sets off in the respect of the 5th and 6th accounting years. For the 7th accounting year, set on or set off, as the case may be, shall be made in the manner illustrated in the 4th schedule, taking into accounting the excess or deficiency, if any, as the case may be, of the allocable surplus set on or set off in respect of the 5th and 6th and 7th accounting year. Substituted for the subsection 1 and the explanation by Act number 23 of 1976, section 12A, and shall be deemed to have come into force with effect from 25th September 1975. Substituted for the words third schedule by Act number 66 of 1980, section 10, and shall be deemed to have come into force with effect from 21st August 1980. Substituted for the words third schedule by Act number 66 of 1980, section 10, and shall be deemed to have come into force with effect from 21st August 1980. 1C. From the 8th accounting year following the accounting year in which the employer sells the goods produced or manufactured by him or rendered services, as the case may be, from such establishment, the provisions of section 15 shall apply in relation to such establishment as they apply in relation to any other establishment. Explanation 1. For the purpose of section and subsection 1, an establishment shall not be deemed to be newly set up merely by reason of a change in its location, management name or ownership. Explanation 2. For this purpose of subsection 1A, an employer shall not be deemed to have derived profit in any accounting year unless he has made provisions for that year's discretion to which he is entitled under the Income Tax Act or as the case may be under the Agricultural Income Tax Law, and the areas of such depreciations and losses incurred by him in respect of the establishments for the previous accounting years have been fully set off against his profits. Explanation 3. For the purposes of subsections 1A, 1B, and 1C, sale of the goods produced or manufactured during the course of the trial running of any factory or of the prospecting stage of any mine or an oil field shall not be taken into consideration, and where any questions arises with regard to such production or manufacture, the decision of the appropriate government made after giving the parties a reasonable opportunity of representing the case shall be final and shall not be called in question by any court or other authority. The provisions of subsections 1, 1A, 1B, and 1C shall so far as may be applied to new departments or undertaking or branches set up by existing establishments. Provided that if an employer in relations to an existing branches, whether or not in the same industry, set up at different periods has before the 29th May 1965 been paying bonus to the employees of all such departments or undertaking or branches irrespective of the date on which such departments or undertaking or branches were set off, on the basis of the consolidated profits computed in such employer shall be liable to pay bonus in accordance with the provisions of this Act to the employees of all such departments on the basis of the consolidated profits computed as aforesaid. Adjustment of customary or inter bonus against payable under the Act, wherein any accounting year substituted for the word brackets and figure subsection 1 by Act number 23 of 1976, section 12B, and shall be deemed to have come into force with effect from 25 September 1975. An employer has paid any puja, bonus or other customary bonus to an employee, or an employer has paid a part of the bonus payable under this Act to an employee before the date on which such bonus becomes payable, then the employer shall be entitled to deduct the amount of bonus so paid from the amount of bonus payable by him to the employee under this Act in respect of that accounting year, and the employer shall be entitled to receive only the balance deduction of certain amounts from bonus payable under the Act. wherein any accounting year an employee is found guilty of misconduct causing financial loss to the employer, then it shall be lawful for the employer to deduct the amount of loss from the amount of bonus payable by him to the employee under this act in respect of that accounting year only, and the employee shall be entitled to receive the balance if any time limit for payment of bonus. All amounts payable to an employee by way of bonus under this act shall be paid in cash by his employer. Where there is a dispute regarding payment of bonus pending before any authority under section 22 within a month from the date on which the award becomes enforceable or the settlement comes into operation in respect of such dispute. In any other case, within a period of 8 months from the close of the accounting year, provided that the appropriate government or such authority as the appropriate government may specify in this behalf of may upon an application made to it by the employer, and for sufficient reasons by order extend the said period of 8 months to such further period or periods as it thinks fit. So, however, that the total periods so extended shall not in any case exceeds 2 years. Application of Act to establishments in public sector in certain cases, if in any accounting year an establishment in substituted for the brackets figures and words subject to the provisions of this section all amounts by Act number 23 of 1976, section 13A, and shall be deemed to have come into force with effect from 25 September 1975. Subsections 2 and 7 inserted by Act number 68 of 1972, section 4, and omitted by Act number 23 of 1976, section 13B, and shall be deemed to have come into force with effect from 25 September 1975. Subsection 8 omitted by Act number 1973 of 55, section 2, and shall be deemed to have come into force with effect from 1st of September 1973. Section 20 reimbursed as subsection 1 by Act number 66 of 1980. Section 11 with effect from 27th December 1980. Public sector sells any goods produced or manufactured by it or renders any services in completion with an establishment in private sector, and the income from such sale or services or both is not less than 20% of the gross income of the establishment in public sector for that year, then the provisions of that act shall apply in relations to such establishment in public sector as they apply in relations to a like establishment in private sector. Save as otherwise provided in subsection 1, nothing in this act shall apply to the employees employed by any establishment in public sector. Recovery of bonus due from an employer. Where any money is due to an employee by way of bonus from his employer under a settlement or an award or agreement, the employee himself or any other person authorized by him in writing in his behalf of, or in the case of the death of the employee, his assignee or heirs may, within prejudice to any other mode of recovery, make an application to the appropriate government for the recovery of the money due to him, and if the appropriate government to such authority as the appropriate government may specify in this behalf of is specified and satisfied that any money is so due, it shall issue a certificate for that money to the collector, who shall proceed to recover the same in the same manner as an area of land revenue, provided that every such application shall be made within 1 year from the date on which the money became due to the employee from the employer. Provided further that any such application shall be made within 1 year from the date on which the money becomes due to the employee from the employer. Provided further that any such application may be entertained after the expiry of the said period of 1 year if the appropriate after the expiry of the appropriate government is satisfied that the applicant had sufficient cause for not making the application within the said period. Explanation about it. In this section and in sections 22, 23, 24 and 25, employee include a person who is entitled to the payment of bonus under this act but who is no longer in employment. Reference of disputes under this act. Where any dispute arises between an employer and his employees with respect to the bonus payable under this act or with respect to the application of this act to an establishment in public sector, then such dispute shall be deemed to be an industrial dispute within the meaning of the Industrial Dispute Act 1947, 14 of 1947, or with respect to the application of the act to an establishment in public sector, then such dispute shall be deemed to be an industrial dispute within the meaning of the Industrial Dispute Act 1947, 14 of 1947, or of any corresponding law related to investigation and settlement of industrial disputes in force in a state and the provisions of that act, or as the case may be, such law shall save otherwise expressly provided, apply accordingly. Subsection 2 inserted by Act number 66 of 1980, Section 11, with effect from 27 December 1980, substituted for the words and figures Section 22, 23 and 25 by Act number 66 of 1980, Section 12, and shall be deemed to have come into force with effect from 21st August 1980. Presumption of about accuracy of balance sheet and profit and loss account of corporations and companies, where during the course of proceedings before any arbitrator and tribunal under the Industrial Disputes Act 1947, 14 of 1947, or under any corresponding law relating to the investigation and settlement of industrial disputes in force in a state hereafter in this section and in sections 24 and 25 referred to as the said authority, to which any dispute of the nature specified in section 22 has been referred, the balance sheet and company other than a banking company duly audited by the Comptroller and Auditor General of India, or any auditors duly section 226 of the Companies Act 1956, 1 of 1956 are produced before it, then the said authority may resume the statements and particulars contained in such balance sheet and profit and loss account to be accurate, and it shall not be necessary for the corporation or the company to prove the accuracy of such statements and particulars by the filing of an affidavit or by any other mode, provided that where the said authority is satisfied that the statements and particulars contained in the balance sheet for the profit and loss account of the corporation or the company are not accurate, it may take such steps as it thinks necessary to find out the accuracy of such statements and particulars. When an application is made to the said authority by any trade union being a party to the dispute, or where there is no trade union by the employees being a party to the dispute, requiring any clarification relating to any item in the balance sheet or the profit and loss account, it may, after satisfying itself that such clarification is necessary by order, direct the corporation or, as the case may be, the company to furnish to the trade union or the employees such clarification such tight as may be specified in the direction, and the corporation, or as the case may be, the company shall compel with such directions. audited accounts of banking companies not to be questioned, where any dispute of the nature specified in Section 22 between an employer, being a banking company, and its employees has been referred to the said authority under that section, and during the course of proceedings, the accounts of the banking company duly audited or are produced before it, the said authority shall not permit any trade union or employees to question the correctness of such accounts, but the trade union or the employees may be permitted to obtain from substituted for the words and figures and in sections 24 and 25 by Act number 23 of 1976, section 16, and shall be deemed to have come into force with effect from 21st September 1975. Substituted for the word and figures section 25 by Act number 66 of 1980, section 13, and shall be deemed to have come into force with effect from 21st August 1980. Section 24, omitted by Act number 23 of 1976, section 17, and again inserted by Act number 66 of 1980, section 14, and shall be deemed to have come into force with effect from 21st August 1980. The banking company such information as is necessary for verifying the amount of bonus due under this Act. Nothing contained in subsection 1 shall enable to the trade union or the employees to obtain any information which the banking company is not compelled to furnish under the provisions of section 34A of the Banking Regulation Act 1949, 10 of 1949. Audit of accounts of employers not being corporations or companies, where any dispute of the nature specified in section 22 between an employer not being a corporation or a company and his employees has been referred to the said authority under that section, and the accounts of such employer audited by any auditor duly qualified to act as auditor of companies, such subsection 1 of section 226 of the Companies Act 1956, 1 of 1956, are produced before the said authority, the provisions of section 23 shall, so far as may be, apply to the accounts so audited. It finds that the accounts of such employer have not been audited by any such auditor, and it is of opinion that an audit of the accounts of such employer is necessary for deciding the question referred to it. Then it may, by order, direct the employer to get these accounts audited within such time as may be specified in the direction, or within such further time as it may allow by such auditor or auditors as it thinks fit, and thereupon the employer shall compel with such direction. Where an employer fails to get the accounts audited under subsection 2, the said authority may, without prejudice to the provisions of section 28, get the accounts audited by such auditor or auditors as it thinks fit. When the accounts are audited under subsection 2 or subsection 3, the provisions of section 23 shall, so far as may be, apply to the accounts so audited. The expenses of and incidental to any audit under subsection 3, including the remuneration of the auditor or auditors, shall be determined by the said authority, which determination shall be final and paid by the employer, and in default of such payment shall be recoverable from the employer in the manner provided in section 21. Maintenance of registers, records, etc. Every employer shall prepare and maintain such registers, records, and other documents in such form and in such manner as may be prescribed. Inspectors. The appropriate government may, by notification in the official gazette, appoint such persons as it thinks fit to be inspectors for the purpose of this Act. Purposes of this Act, and may define the limits within which they shall exercise jurisdiction. An inspector appointed under subsection 1 may for the purpose of ascertaining whether any of the provisions of this act has been compelled with require an employer to furnish such information as he may consider necessary at any reasonable time and with such assistance if any as he thinks fit enter any establishment or any premises connected herewith therewithin and require any one found in charge thereof to produce before him for examination any accounts, books, registers, and other documents relating to the employment of persons or the payment of salary or wage or bonus in the establishment. Examine with respect to any matter relevant to any of the purposes aforesaid, the employer, his agent or servant or any other person found in charge of the establishment or any premises connected therewith or any person whom the inspector has reasonable cause to believe to be or to have been an employee in the establishment. Make copies of or take extracts from any books, registers or other documents maintained in relation to the establishment. Exercise such other powers as may be prescribed. Every inspector shall be deemed to be a public servant within the meaning of the Indian Penal Code 1860, 45 of 1860. Any person required to produce any accounts, books, registers or other documents or to give information by an inspection of under subsection shall be illegally bound to do so. Nothing contained in this section shall enable an inspector to require a banking company to furnish or disclose any statement or information or to produce or give inspection of any of its books of account or other documents which a banking company cannot be compelled to furnish, disclose, produce or give inspection of under the provisions of section 34A of the Banking Regulations Act 1949, 10 of 1949. And now I will explain about the penalty. If any person contravenes any of the provisions of this act or any rule made thereunder or to whom a direction is given or a requisition is made under this act fails to compel with the directions or requisition, he shall be punishable with imprisonment for a term which may extend to 6 months or with fine which may extend to 1000 rupees or with both, and offences by companies. If the person committing and the offence was committed was in charge of and was responsible to the company for the conduct of business of the company, as well as the company shall be deemed to be guilty of the offence and shall be liable to be produced and proceeded against and furnished accordingly. Provided that nothing contained in this subsection shall render any such person liable to any punishment if he proves that the offence was committed without his knowledge or that he exercised all due diligence to prevent the commission of such offence. Notwithstanding anything contained in subsection 1 where an offence under this act has been committed by a company and it is proved that the offence has been committed with the consent or convenience of or is attributable to any neglect on the part of any director, manager, secretary or other officer of the company, such director, manager, secretary or other officer shall also be deemed to be guilty of that offence and shall be liable to be proceeded against and punishable and punished accordingly. Explanation for the purpose of this act section. Company. Company means anybody corporate and includes a firm or other association of individuals, and director. Director in relation to a firm means a partner in the firm. Cognizance of offences. No court shall take cognizance of any offence punishable under this act save on complaint made by or under the authority of the appropriate government or an officer of commissioner in the case of an officer of the central government and not below the rank of a labor commissioner. In the case of an officer of the state government specially authorized in this behalf of by the government. No court interfere to that of a presidency magistrate or a magistrate of the first class shall try any offence punishable under this act. Protection of action taken under the act. No suit, prosecution or other legal proceedings shall lie against the government or any officer of the government for anything which is in good faith done or intended to be done in pursuance of this act or any rule made thereunder. Inserted by Act Number 66 of 1980, Section 16, and shall be deemed to have come into force with effect from 21st August 1980. Hi friends, thank you very much for watching the video. Thank you for watching. If you found this video helpful, don't forget to like, share and subscribe to Posh Pro HR. For more insightful HR content, stay informed, stay comments. Thank you friends.